Συνεχίζουμε με την συζήτηση μεταξύ της Ελίνας Ασιμακοπούλου και της Xandra Kramer, η οποία δεν έγινε πριν λόγω τεχνικών προβλημάτων. Ευχαριστούμε για την υπομονή. Οπότε, Ελίνα, ο λόγος σε σένα. Ελπίζουμε τώρα δουλέψεις.
Hello, Xandra. Can you hear me now?
Yes, I can hear you perfectly.
Okay, nice. So I will follow on, Xandra, according to our outline with unifying these two initial topics we have, because I have already made some introductory remarks about the rule of law and the connection with efficiency. I have also made a reference to the European Commission for the Efficiency of Justice and the survey that was published on October of 2024. We have heard in the first panel, I'm not sure that you could hear it, a very interesting discussion about court management, actually one of the cornerstones of the efficiency of justice and the reducing of judicial delays. And I will follow on with one remark and one distinction from my point of view, and I will give you the floor. The remark that is actually also has already been mentioned is that all the approach that we must make for the efficiency of justice must be human-oriented. There must be a human rights orientation in this. And the distinction is a distinction that I've made in my mind as inner efficiency and outwards efficiency. Outwards efficiency has to do for me with court management, but we have already heard very interesting remarks, and the use of artificial intelligence in civil justice. We will follow on with a discussion on this, and some remarks for inner efficiency has to do with the law provisions we have on procedural laws and how we make the interpretation of them. For example, the restrictive treatment of adjournments of trials, the broad treatment for the court's possibilities to see and emphasize on the merits of the case and not on procedural obstacles, the emphasis on written procedure but with the proper activating of judges' power to ask for oral conduct when it is necessary to clarify the facts of the case. Especially, just to underline for the emphasis on the merits, on the substance of a case, and maybe have preliminary hearings for the cases that confront procedural obstacles, and we cannot have, we are not obliged to have oral hearing or a court hearing for just, testifying the procedural obstacle just. We have a broad emphasis of European law on the actually on the evidence procedure nowadays. European legislation on special allocating of burden of proof in certain cases, on evidence collection, on pre-action protocols, on evidence disclosure. We see an emphasis on the merits of the case. And so I think this is actually dimension for reducing procedural and delays. So after these remarks, I want to set you two questions. First of all, what is your view on the judicial delays as a threat to the rule of law? What are the main points to make this connection, to stabilize it more? And what do you think actually are the key causes for delays in civil justice? And what might be the remedies? And we can leave artificial intelligence for spatial contribution, but we can also refer also to this at this point.
Okay, thank you very much. These are, of course, two very complicated questions. I think if we look at the human rights discussion, starting, of course, from Article 6 of the European Convention on Human Rights, but for the EU, also Article 47 of the EU Charter, then having efficient procedures, having actual access to justice has always been connected to the right to a fair trial, and that is also embedded in the rule of law. So I think to avoid judicial delays, which is of course a very old, still very relevant discussion, is to live up to these fair trial principles, and those fair trial principles in turn establish and solidify the rule of law principles. I think this is necessary in any democratic state, but also, of course, it has a lot of actual societal relevance, both for individual citizens that want to resolve their disputes. They don't want to wait for years for a case to go through court, but also for businesses. And that is not only an interest in the cause of, or in the context of the rule of law and fair trial, but it also has economic value for companies. So it supports economic growth and competition if cases are managed through the courts and can be resolved also by courts and not only in arbitration, because of course many companies nowadays use arbitration. And one of the issues there, of course, also is that courts sometimes may not have the necessary specialization, but also that these procedures take too long. What I thought is in preparing this, I also looked at the most recent judicial scoreboard data from the EU that are, of course, based on the CEPES data. And what was a good thing that the conclusion, the overall conclusion between 2012 and 2022, so in a long span of 10 years, there was actually some improvement in speeding up justice. So although the caseload has increased a little bit, though not drastically, you see that on average, the duration of proceedings has gone down. And I think that is a very good sign. Of course, case management, I think, is essential in that, and indeed, now that we're no longer the introductory panel, but that we're following up on another panel where this court and case management has been discussed a little bit more in detail. But I think indeed that is really crucial. We see that in traditional adversarial systems, mostly common law systems, but also some other systems where we used to have parties that can do their thing and the judges that would be quite passive. That simply doesn't work. Procedures and also the law is too complex to just let things drag on. So we need to have active judges that can interfere, courts that set specific deadlines, and courts that also themselves, of course, stick to these deadlines in order to speed up justice. And of course, this case management needs to have a basis in the law, but also there, and I think that was also emphasized in the previous panel, that's also work that really needs to be done on the ground within the courts, within individual courts at the national level, but also within individual courts, where courts will have to learn how they can speed up procedures, how they can organize their time more efficiently, and also how they can learn from other courts that perhaps function better. But also within the EU, of course, there's the possibility to learn and to have best practices looking at what is happening in other courts. Because we have now all those statistical data of which courts perform better than others, or in which countries, on average, the procedure is more efficient. We can also learn from that. So courts should also visit other courts and see what's going on there, and to learn on how to organize things better. Then, of course, and that is more it's not really the court management or case management, is that special procedures have been introduced also at the EU level, so the small claims procedure, order for payment, and that is also tendencies that we've seen in other countries, for instance, also in the United Kingdom, of course, to track certain cases, because cases are very different, and on average, the more complex cases, of course, take much more time. But if you track these cases from the start on, you can already ensure that simpler, easier cases get through the system more quickly, and then there is the time and the attention that perhaps more complex cases need. But that other cases, so the small claim cases or the payment orders, the simpler cases, get through the system and are not hampered because the court as such is clogged and maybe not so efficient. I think we will also talk about digitalization perhaps a bit more later on, if I understand correctly. But of course, it is really a very good opportunity if you digitalize courts and processes, that you can much more easily track cases, extract relevant information, schedule hearings in the most efficient ways. And I think that is really an opportunity for courts to make an improvement. Another thing that we could emphasize is the use of ADR, and also, of course, from the EU perspective, that has been very much emphasized, because not all cases need to go to the court, or maybe if they come to court, they can also reach a settlement more easily. And I think that is partially a case management that can also be done by the courts, but of course also the legislator can intervene then there, and we have seen it in a number of countries in more recent years. A mandatory mediation has also been introduced as a way to ensure that cases that perhaps don't need the full-fledged procedure, that they can be resolved through mediation and even before going to a trial. Also, what I wanted to mention is the ELI Unidroit model rules on European civil procedure, in which I have been heavily involved in the preparation, which was between 2013, that's when it started, and they were adopted in 2020. And also there, we didn't only look at how can we sort of harmonize these rules and how can we have an overarching system of civil procedure for the EU or for Europe, but we also looked at how procedures can be improved. And you will see in those ELI Unidroit model rules that we have identified three overarching issues, and that's the principle of cooperation, that of proportionality, and that of settlement. And each of these three principles are also geared to having an efficient procedure and avoiding delays, because the idea then is that parties and the court collaborate, so there's not a clash, but there is actually a collaboration in order to ensure a smooth running of the procedure, to have proportionate procedure. Indeed, the way out, perhaps if a settlement is possible, but each of them gearing and collaborating in reaching a good dispute resolution in the end. And then, because you also asked about the causes, but I think I spoke too long. But I think on the other side, of course, if there is no proper court management, and if the parties have a too big say in having all sorts of interim appeals, and another response and another delay. So I think the causes of delay if you don't have a good court management system, a case management system.
Yes, I totally agree, and that was actually my point for the emphasis on the merits of the case. I mean that the collaboration between the judges and the litigants offer this, these smooth procedural stages, to go smoothly through procedural stages to see the merits of the case, actually. And we can see it actually in many jurisdictions, such as German procedural law, that adopt this jurisdiction, adopt German procedural law, Verhandlungsmaxime, adversary system in a way. But there is the provision of 103.9, if I am correct, for the Prozessleitung, actually case management. So this is compatible if we want to be. And so follow on with the use of artificial intelligence, this big topic, for the judicial systems. As I can see in international recent bibliography, is very useful in criminal proceedings, for example, for data analysis to predict possible repeat of the offender. But artificial intelligence has the potential to for the significant speed up for the adjudication of differences also in civil disputes. How can artificial intelligence can help? With automated document review, for the use of predictive analysis, can analyze previous cases and predict the outcome of a dispute. Virtual mediation and promoting the alternative dispute resolution. And of course, the improved communication between the courts. We have the regulation, the recent regulation of 2023 with the number 2848 of European Union. And the last one, and I'm a little bit, I have a very little skepticism for this, the automated decision making. I think that this point has many parameters, such as the data protection law, according to 22 article of GDPR, the suitable data that we have, parameters for transparency, and we can discuss on this. And accept a maybe romantic comment that this automatic decision-making keeps a distance from philosophy of law concerns. And I have mentioned in the material that I shared with you, Ronald Dworkin's comment about the role of judges. Judges' role is to keep the integrity. Judges who accept the idea of integrity try to find the coherent set of rights and obligations in order to set the best possible creative turn of political structure and legal doctrine of their community. And I want to ask you, how can you use AI for make civil dispute resolution mechanisms more efficient, but actually keep this legal doctrine, you know, live and at the core of our interest?
I think this is an intriguing question, and also one that one cannot easily answer, and there are also lengthy discussions on that. I think indeed we should separate these two possibilities and great opportunities that digitalization and AI offer. And the one is indeed a really supportive role, where, well, you mentioned all the examples where we can have a predictive technology, but also yeah, AI, of course, has the capacity to really extract a lot of data. So also if there are big court files, that it can help in summarizing the relevant facts and categorizing them to make them yeah, more accessible. And also a very practical implementation is to keep track of cases, so really case tracking, and also giving reminders in the system, hey, this case has been pending too long, or the next step, the next deadline is approaching, and something needs to be done. And that can help, of course, if a case file is digitized, in both triggering courts, court administrators, but also the parties in, hey, the next step is due and something needs to be done. And I think that's also a very practical application that can be very useful. And also within the courts, it can further help in case management, for instance, by an effective case distribution. So also seeing which judges are available or have specialty or whatever, so that it can distribute the cases among judges and within the administration more efficiently, but also by an effective planning of hearings and an effective planning of yeah, writing the judgments. And that's also something that in the Netherlands we have focused on. And then I'm speaking specifically from my experience with the court in Rotterdam. On average, the delays in Dutch procedure are not so big. We have efficient procedures, but still the delay of procedures is still something that we're working on and always concerned about. And what very small interventions was, for instance, what we often see, there's a day of hearings, and then there's no specific scheduled time for writing the judgments. And of course, then the files go back in the yeah, electronically or literally in a drawer. And if you then 6 weeks later, when maybe the judgment is due or whatever it is due, have to get the file up and running and going through all the documents again to write the judgment, that's not efficient. And AI can also help in really ensuring, okay, this judge or this court session panel has had a couple of hearings. Now we need to have scheduled time in order to write these judgments, and not in 6 weeks when there happens to be time, that there needs to be a good time management. And there, of course, digital systems can also help. The last one that I wanted to mention at this more practical level is compliance management. That is also much easier through digitization and artificial intelligence, because then data can be gathered, data can be compared, and then you can also more easily track what the bottlenecks are in the procedure, and thus have more targeted interventions. But then the point, and that is really another issue, is in how far can we go further than this really supportive role of artificial intelligence and digital tools in general, by having what we call a robot judge. And there I agree that there are these ethical concerns, and that there are concerns about also judicial independence. I think later today there will also be a panel, if I'm correct, about judicial independence, more specifically in the Mount Scopus project. And of course, if you really give way to, okay, let the computer decide what needs to be done based upon previous case law, then there are all sorts of problems in independence of the court, because no one can really oversee what is in the system and what comes out of it. It's simply humanly impossible to oversee how certain data are generated, mixed, and the prediction that comes out is maybe nice for lawyers to say, oh, based upon case law of the past 10 years, it's probably going to go that way. That's a very nice tool for lawyers. But for judges to base a decision upon that, then of course the law doesn't develop anymore. We don't really see what's going into the system. So it lacks a transparency, and it lacks the true judge experience and the human touch that most cases need. On the other hand, there are, of course, certain cases, and there's especially certain standard cases, and that is not very new. For instance, these orders for payment or other more standardized cases, cost orders, or other more standardized procedure. And there, of course, it can be almost fully automated. There needs to be a check in the system. If there is something special that needs to be flagged up, that a judge or someone else needs to take a look at that. But otherwise, those very simple cases, there I don't see a problem in having the system decided, because that is standard data.
Such as, for example, to follow on with our next topic, I suppose you mean small claims procedure. And I'm wondering if small claims procedure can be a model for the necessary procedural amendments, including the digitalization of elements of the procedure. The format, documents, the automated decision-making. And for me, I think the most crucial point for using small claim procedure as model statute and using for decision-making artificial intelligence is the distinction between contested and uncontested cases.
Yeah,
So I
would
see
agree.
no problem, actually.
No, I think what justice needs is tailored justice. So complex cases need more complex structures, and there are also especially the human touch there, and there the AI can have the important supportive role, because a lot of data can be put into the system and you can get out of it what is most relevant. But there, the human judge as an eventual or in the end decider is very important. But for small claims tracks, there I think artificial intelligence is, again, as a supportive role, of course, in filing the case, in having ways of mediation, so virtual mediation can be an option. There are chat options, etc., that can really flash out the procedure and speed it up. But also these more standardized cases would also lend themselves to a more automatic decision making. But of course, not all small claims in having a low amount are necessarily simple cases. And I think that is also important to take into account. And you cannot simply impose this model to all cases, because complex cases are complex. There are difficult questions of law. There have to be procedural incidents in order to do justice to the complexity of the case. So you cannot say, oh, the small claims model is nice, it's simple, it's straightforward, we can digitize it to a great extent, and that is what we can use for all cases. I don't think it is possible, because you have to diversify within the law and see what a specific case needs.
Remarks for latest amendments in Cyprus civil procedure and Greek civil procedure law. Cyprus civil procedure latest amendments emphasize on case management, and what we have already said before and on the panel that was previously heard. And in Greece, we have the adoption of written procedure in 2015 for a very broad range of disputes, except special jurisdiction disputes, okay, there are some. And we have also the new law for the judicial charter law in 2024, recently, from September on. for emphasizing to one-member judge courts. Do you think that this could be a solution? I mean, case management, we have already discussed it, and we agree that it is. One-member judge courts and written procedures are solutions, could be solutions for, accelerating the length of judicial proceeding.
Yeah, well, of course, this is also very dependent upon the system that we're in, because
we have
usually,
actually adversary system in Greece, I could say.
yes. But of course, the more adversarial system is, or the more the idea always was that everything has to be done in lengthy hearings. That is, of course, not efficient. But for instance, in the Netherlands, we've always had a strong tradition in written judgments, which is good. But there we have seen also a little bit of a counter trend in saying sometimes this hearing is necessary to really see, okay, what's going on. And it can even be in small claims cases, where often also because then parties are not obliged to have legal representation, and then it's often not really clear what's actually the problem. And then sometimes scheduling a hearing, which may perhaps also be done online, this of course can be far more efficient in the planning. Then to really see a judge that can really ask, hey, what is actually your problem? Can we solve this? Can we come to a resolution? So I think that these oral hearings are or can be very important. But again, it depends on where you come from. If you are from a tradition where you've always had very lengthy oral hearings, well, I think we can agree these are not very efficient. But again, coming from a tradition where we had a lot of written procedures, and sometimes this written procedure doesn't really resolve it because paper needs to be moved forward. And if the problem is not really clear, so I'm not really clear what the problem is, then maybe you do need an oral hearing. What we do have in the Netherlands, so I also have sat as a deputy judge in court cases. And what is really a difference also between, for instance, my jurisdiction and other, for instance, English jurisdictions, is the length of oral hearings. And sometimes people were surprised that, well, also if we have a bit more of a complex civil or commercial case in the Netherlands, that we say, oh, we have a hearing scheduled of an hour and a half, and that's basically it. But that means that before the oral hearings, most of it should have been resolved. So also in the Netherlands, we have introduced, that was already back in 2012, that from the start, parties have to substantiate their case. So already in the written summons, you cannot keep your information and say, oh, I will add a little bit of information here and there during the procedures. During the procedure, no, there is the obligation for the party starting the procedure to give openness from the start and really say, this is the whole issue. And then that immediately gives the possibility of the other party to reflect on all those issues, and then the case can be prepared for perhaps an oral hearing. And also what our judges would usually say also to the lawyers involved in the case, we have read the case file, we have seen what's there, so there's no necessity to repeat everything. Can you give a brief statement, and then the other party will have their say, and then the judge actively tries to manage to see, hey, can something be settled, or what do you agree on, what do you not agree on, what do you want us to decide, okay, this specific point, then that may go into that direction, and then the court really directs the case quite quickly through those hearings. So we don't have hearings that take a whole day or a day and a half. Of course, in criminal cases, sometimes we do, because there we have the big, very complex issues. But in general, civil and commercial cases, we would have hearings for an hour and a half, 2 hours, 2.5 hours max. And well, there are some exceptions, but also the oral hearings as such are speedy. And then they can have added value. And then the procedure doesn't necessarily have to be completely in writing.
I totally agree with your comments, and especially for the comment for the responsibility of lawyers to have a specific goal for the hearing and not just repeat the same and the same. It reminds me this new terminology for design thinking, even in legal matters, and it's another discussion. This, we don't have time to make it now. Thank you very much for your contribution. Again, accept our apologies for this initial inconvenience with the online system. I'm very happy to see you again and for our discussion. I always admire your academic excellence. I read your books and your articles, and I'm very happy to be here with you today. Thank you very much.